the possession of that item is always possession of a weapon, regardless of how it's used, such as the nunchucks, the brass knuckles, the dirk dagger knife. Those typically can be charged as a felony or a misdemeanor. Earlier, I explained what a wobbler is. It's a crime that wobbles between being a misdemeanor or a felony. A misdemeanor having a maximum punishment of 1 year in the county jail, and a felony having a maximum punishment of more than a year in a state prison. Obviously, the felony is more serious. It's a more serious crime. There's more serious implications with having a felony conviction on one's record. Your standard weapons crimes, you will find if one is charged with one of those crimes and that person has no prior criminal record, it's usually going to be a misdemeanor charge. And it's usually fairly common that those cases can be settled for something that ultimately results in a non-conviction, by which I mean, you do some community service, do something affirmative to show that you understand you made a mistake by carrying around that object, and leave the district attorney with the impression that it's not going to happen again. And most often they won't be out to get a conviction on your record. A felony is more often charged when someone comes in to the case with a prior criminal record and where it looks like they were really carrying around this object with the intent to hurt somebody. Now, how do you make that distinction, whether someone's carrying it with the intent to hurt somebody? Well, throughout my life growing up, I knew plenty of kids who had brass knuckles. Part of the reason they had them were because they were illegal. But those people never had any intent to use it. They would hold it, they would show it off to their friends, they'd laugh about it, but at no point did you see them actually putting them on and threatening someone with them. But if the individual who's caught with the brass knuckles does have them on, is engaged in a fight and has them in their pocket, raises the inference that they eventually would have put them on, or they're walking around looking for some trouble, it appears that way, then that person can be charged with actually using it with the intent to commit the assault. And like I said, if the person has a prior criminal record and looks like there was no nearly innocent reason for having the weapon on their person, then it's quite likely that that person can be charged with a felony. Now, a firearm is a totally different category in and of itself. Firearms, as I mentioned, there's a huge epidemic of firearm tragedies in our country at large, in every big city, including Oakland. I think there's probably less firearm issues in San Francisco, but that's not to say we don't have our own problems here. And obviously San Mateo County and Santa Clara County have their own problems. Marin, probably to a lesser extent, but it's a problem everywhere. So what happens when the person is charged with a firearm crime? Again, the district attorney can approach these cases, determine whether it should be charged as a misdemeanor or a felony. Whether a firearm is charged as a misdemeanor or felony depends on more technical circumstances. If the person has a prior felony conviction, that person will always be charged with a felony, being a felon in possession of a firearm. There's also various laws prohibiting the concealed carry of firearms, and as to whether the individual who commits that should be charged with a misdemeanor or felony depends on the various circumstances, including their status, such as whether they're a felon or not, whether they have prior firearm convictions, whether they're a drug addict, and the circumstances in which they are carrying it. Is it in a vehicle? Is it on their person? Is it loaded? Is it a registered firearm with the California Department of Justice? Is it known to be a stolen firearm? These are various factors that are considered when prosecutors determine whether the individual should be charged with a felony or a misdemeanor. There are also various factors that courts consider when a defense attorney asks the court to reduce the felony to a misdemeanor over the district attorney's objection.